I'm Ty Mangrum, the firm development director, and I'm going to be introducing Jeff today. As you all know, this is a book review on his new book, The Ladder of Success, an Asset Protection Planning Primer, a review for business owners, professionals, corporate executives, and real estate investors. Little introduction to Jeff. He received his law degree at the honors from UCLA School of Law and served as a military judge with the rank of captain in the U.S. Marine Corps. Mr. Matson has been a professor of law and business, estate planning, and advanced taxation. He's highly sought after and respected speaker and educator, and he's published numerous legal articles. Mr. Matson is the founder of Wealth Strategies Council, this planning and business transaction department of Matson Voorhees and Bull Matson Cagle and Aguilera LLP in Orange County, California. His practice areas include business and estate planning, asset protection, probate and trust administration and litigation, real estate, and offshore structures. Mr. Matson has been designated as one of the nation's top 100 attorneys by Worth Magazine, as Southern California Super Lawyer by Los Angeles Magazine, and he's listed in the best lawyers in America. The nationally renowned attorney rating service, Avil, has rated Mr. Matson a perfect 10 out of 10 superb, and besides continuing to achieve the highest AV rating, he's been designated a preeminent lawyer by the prestigious attorney rating directory, Martindale Hubbell. And with that, we'll turn the time over to Mr. Matson.
Thank you, Ty. It's a pleasure for me to be able to be with all of you today. Some of you it's still morning, and those on the East Coast, it's already afternoon. It's kind of an overcast day here in Orange County, but we can still see the San Bernardino Mountains, the Anglers Crest Mountains. We can see the Pacific Palisades, or not, the Palos Verdes Peninsula, and I can barely see Catalina. There's a lot of clouds out there. But I have about a 270-degree vista from my window, so it's pretty nice. But most of the time I'm either looking down, looking at a paper, or looking at the phone, or looking at the computer. I'm very glad to be here today and to talk a little bit about my book. And one of the reasons I did this is several of you have said that you're going to use the book as a marketing device. And so it was suggested to me that I give a review about the book and then maybe talk a little bit about marketing and how the book can help you with marketing. And I think it will and it can. So anyway, I'm just wanted to explain to you, first of all, why I really wrote the book. It's really a book directed towards clients and advisors. It's not a legal treatise, but a lot of lawyers, I think, can learn a lot from the book. I wrote it in a way that I tried to be as concise and simple as possible in making the explanations. There's some good diagrams in it. And then I put a lot of case studies and hypotheticals in that people can really relate to. I also think it clears up some misconceptions that many clients would have. And it provides very practical and concrete advice, but it doesn't have do-it-yourself forms and very little do-it-yourself strategies. So that's why I think it will help lawyers to be able to use it as a marketing device or advisors. And there is a special chapter for physicians and dentists, which might make it more interesting for them. Asset protection planning is really a process of arranging and setting up your assets in a structure that minimizes risk and makes it much more likely that creditors' claims are going to be successful against the client. And it's part of estate planning, and I've mentioned this before on many of the seminars that I've given for. I give a lot of national webinars for National Business Institute, and we give our own, and then I've also taught for Wealth Council and other educational forums that as attorneys, we have a duty to talk about asset protection planning with our clients when they come in for us to see us about estate planning. And there are some law review articles that have made mention of that. But what we're really trying to do with asset protection, we're trying to lower the financial profile of the client, and we're trying to make it possible for the client to maintain control while at the same time safeguarding their assets. The book goes into an introduction and talks about a little bit about the parlance of asset protection planning. It talks about inside creditors, and those are creditors that have a claim against the business entity itself. So a lot of our clients who come in are business owners, they're physicians, they're real estate professionals, and they have an operating business, and that's really the first step on the ladder, as you'll see in just a minute, that the book goes into. And they need to have an operating entity that will protect them against claims against that operating entity. And so they need a C Corp, an S Corp, or a limited liability company if they're in the business of providing any kind of services or products. And that's the first thing we look at. If they have real estate assets, they obviously need to be protected too, need to be properly insured, and an LLC is a great vehicle for protection. Outside creditors are those creditors that have claims against the client personally. We all, if we're practicing attorneys or advisors, we face personal liability for malpractice. Physicians and doctors and dentists do also, but also people like architects, engineers, CPAs, and then if you're a business person and you sign a personal guarantee, then you're facing liability. If you're a business person and you're in an environmental impacted business, you're facing personal liability. Nowadays, there's all kinds of personal suits that are brought against business people, and sexual harassment, discrimination, and other kinds of cases like that. If you're a seller of a business, you have a potential claim against you by the buyer. A lot of buyers can't operate the business as successfully as the seller, so they'll have buyer's remorse and try to come back against the seller. So almost everybody can use asset protection. I'm on the PowerPoint presentation, I've got a list of the different kinds of claimants that there might be. Even elderly people who still drive, they could injure somebody, and that injured person would be a claimant against their estate. So we have children who come in, adult children who come in and say, you know, my dad shouldn't still be driving, and we need to protect his estate and his assets. One of the things that several years ago, it was maybe 6 or 7 years ago, and maybe more than that now, in San Antonio at the Wealth Council Symposium, I made a presentation along with a couple of other estate planning attorneys and asset protection guys, one of whom was my good friend Ken Vanaway in Texas. And we came up with a sort of a strategy, and Ken helped develop this and used it himself as a sort of a ladder of looking at different kinds of problems for the client. And I kind of took the beginning of that, and I've elaborated on it, and I've made it more specific in my book. And so that's why I called it the ladder of success. So there are different rungs on the ladder. The first rung, or the first step, is the business entity. And so some clients may not even have this step to consider because they're not involved in any ongoing business, but many are. And then the second is the basic estate planning. Then we look at exemptions and marital planning, and then liability protected entities, which are mostly LLCs. Then we go into the domestic structure, planning with domestic asset protection trust, and offshore planning with offshore trust and LLCs. And then there's the advanced estate planning techniques like GRATs and IDITs and other charitable remainder trusts. And I'm not going to go into that a lot, and I don't really go into that much in the book either. I do have a chapter on it, but it's just sort of general. But to give the client an idea of those things being available. So the first chapter kind of introduces this concept and why I wrote the book, and then chapter 2, it talks about the need for asset protection. And the need really comes back to the fact that we live in a society where there's a haves and have-nots kind of classification, and the have-nots want to have what the haves have. And so there's a lot of lawsuits that have proliferated over the years. There's aggressive plaintiffs' attorneys. There's a lot of different claims of liability under doctrines that were heretofore unknown and that have crept up over the last few years. And so these expanding theories of litigation have given increased emphasis to asset protection. I just met with a client this morning that's going to set up an offshore structure, and they're just really worried about things, the economy, they're worried about the political system, and they want to have an offshore structure just because and they're not really a target of any potential lawsuits. But they just feel like they want an offshore structure just as a hedge. And so potential liability is a major concern to many professionals and persons of high net worth. These people are worth probably, I'd say $35 million that were in this morning, and they're going to do an offshore structure just because they don't have the confidence that they used to have in the government and in the political stability of the United States, and they want to be able to make sure that they have a hedge if something happens. And by the way, the corporate form of doing business is always, asset protection has always been around, even back into the 16th and 17th century. That's when the corporate form of doing business was instituted, because people were worried about business claims being able to be assessed against their personal assets. So it's not as if asset protection is new, it's just that it's been given an increased emphasis because of what's going on. So why the increase? The victim-oriented society, people want to blame somebody for something and then they want to be compensated for it. The deep pocket theory, plaintiffs' lawyers are very aggressive. There's a lot of lawyers now who graduate from law school who can't get a job. They hang out their own shingle, and they're desperate for work, and they'll take any kind of a case. And they figure there's a nuisance benefit at some point. And then there's an increased media and society awareness, and there's a high notoriety for malpractice and other errors and omissions types of actions. So I go into that in Chapter 3, and frankly, I think that's, if you use the book as a marketing device, it's a good way of the clients focusing in on their own problems and sensing that they need to take steps to asset protect. Chapter 3 talks about the limitations. I'm not going to go into this a lot. In fact, in the chapter, most of the chapters are just very succinct. They're not really detail-oriented. One of the good things I think I do is that I include a lot of fact situations and hypotheticals, and there's some diagrams. And so it's really easy to follow. So when I have a client come in for asset protection, by the way, when we set the appointment, we offer the book as part of the appointment. And when I have a client come in on asset protection, I charge a minimum fee of $500. As contrasted to when I have a client come into estate planning, I give a complimentary first visit. Because if the client knows how much I'm going to charge for the estate planning, if it's a basic estate plan, as long as they know what our fees are, I'm relatively confident that I can close. And if the client wants to come in for say a living trust, a regular just living trust program, if they know what my fees are and I can't close on that, then I ought to be ashamed of myself. I ought to just go flush myself down the toilet, because that kind of a client, they're coming in with a need, and you should be able to close on them and build a rapport. But with asset protection planning, it's a different thing. First of all, it's more expensive. The client doesn't really understand everything that they want, And sometimes you don't even want to represent the client. And so they've spent an hour of time telling you what a bad guy they are, and you don't want to have anything to do with them. So we always charge I charge a $500 consultation fee, but I also say you'll get a copy of my book too, a complimentary copy of my book. So that can be a way that you can use the book as a lead-in to get clients to come in, and offer them a copy of the book as a lead-in when they come in for that appointment. The book is simple and very explanatory of basic concepts. It talks a little bit about the fraudulent transfer law, bankruptcy, and money laundering, but not to a great extent. It's not supposed to be, an academic explanation for other lawyers. Chapter 4, it talks about the ladder of success, the different rungs on the ladder, and I've already talked about those. But I think it's really a good approach to go through with a client to make sure that they have got all their bases covered. And so when I go through and explain things, I can use this ladder sort of as a way of, if they do have a basic business entity, we can talk about that. I remind them that they need to do their basic estate planning, and then so on and up. And then we go through the ladder and we determine what's best for their needs. And by the way, with asset protection planning, most clients want to act now. They're motivated. And so you want to try to close, I think, on the first visit. You don't want to take time to kind of review it or anything else. They're ready to go now. You can get the clients I met with today. I'm doing an offshore structure, and they're signing the retainer agreement now. It was very easy to get them to commit, and it's a substantial fee. And I requested 2/3 of it up front, and so we're going to get a check for $25,000 right up front. And it's easy to get with the asset protection. Let me put it this way: it's not easy, but it's easier because the client feels the need. And when they feel the need, then they're willing to take the action. And there's 4 steps to closing, and some of you have heard me talk about this at other programs on marketing or practice development. And the 4 steps to closing are, number 1, and I'll give you an example. The client comes in and they say, well, you quote them the fee, and you told them what you recommend that they do, and they say, well, I'm going to think about it. And then what I say is, well, these are if you're going to think about it, which you should, these are the 4 things you need to think about. Number 1, do you have a need? And usually they're going to say, well, yeah, that's the reason I came in. And so obviously I have a need. And then number 2 is what I've suggested and proposed satisfy that need. Does it meet your objectives? And if you've explained it right, and you don't need to go into a big esoteric academic explanation, very brief and short, and I just diagram it out on a notepad. I'm an old-fashioned guy. I have a partner who does everything on the internet and uses a screen and everything to have everything presented, but I'm kind of an old-fashioned guy. I do use the screen occasionally, but I'm just saying for most clients I just diagram it out, and I show them how what I recommend meets the need. Then the third, so the first is there a need? The second, does what you propose satisfy the need? And then the third is the most important. Do you have a level of trust and comfort with me? And you directly ask the client that. And if you've done your homework and if you've established the bond in the proper way with the client, then they're going to say, yes, I have. I feel good about you, and that's an important part. And then secondly is the price fair, or lastly is the price fair. And the reason the price is fair is because it's not an expense, it's an investment. They're investing in their assets. So I like to tell people, hey, you bought that office building for $2.5 million. Well, it really didn't cost $2.5 million. It cost $2.525 million because of the $25,000 fee that's involved for me. That office building just cost a little bit more because you want to protect it. You want to make an investment in it to have it done right. And so that's the way I approach closing, and frankly, I've done pretty well. And I think I try to get the client to commit right then. Now, if it's a client that's more up into the really high net worth, above 10 million, we had a client that 60, 70 million, then we're going to want to do a feasibility study and an analysis, and we do a blueprinting that my partner Tim Voorhees has made famous, and so we charge a design and analysis fee for somebody that's more complicated. But with a lot of asset protection planning clients, they're willing to act right now, and you can, strike while the fire's hot, take advantage of the fact that they have that need and commit them down. So anyway, the ladder of success is a good way of just approaching things, and I think it's a very good way for presenting asset protection planning to lay people and to advisors, is by letting them see how there's all these separate things and options and methodologies that they can adopt. The Chapter 5 goes into the types of business entities and the business selection factors. I won't spend a lot of time on that. That's another entirely, we could spend, I give continuing education programs for the last 8 hours on selecting the proper business entity. I try to make it very brief and short in the book, but it's something that people appreciate. And I just had a client call this morning. My secretary tells me that wants to form a corporation that had read the book and wants to make sure that he's got his operations in a corporation that he's going to start. So I think it's a good idea to have this little presentation and to talk to clients about if they do have a business. Some of the clients are just investors, or they're wealthy people that have money already, and then they're not doing operating businesses other than real estate. So this may not be that relevant. Chapter 6 goes into is just a small explanation about basic estate planning. But what I do when I do an asset protection plan, I always throw in the basic estate planning. It helps to justify the fee, and also I just feel a moral obligation to take care of the client in their basic estate planning needs. So if I'm setting up some LLCs or a domestic asset protection trust, I'll also set up a living trust and do wills and durable powers of attorney and everything. And if they already have one, I might want to restate it, and I throw that in as a service, because if they come in to see me about asset protection planning, that really involves estate planning. And it's a way I can do the estate planning very simply. And it makes it so much more real to the client, and they feel like they get more of a value to it. So we do that. Chapter 7 talks about the limitations, bankruptcy considerations, exemptions and protections, marital planning, and joint ownership of property. One of the things I wanted to point out is in Chapter 2, and I skipped over this really, that one of the things Chapter 2 does, it takes the client through the process that a creditor would go to if they got a judgment against them. And so it's very enlightening for the client to understand how a creditor would go about collecting on their judgment. And most clients don't understand what would happen. And so Chapter 2 really is a very succinct roadmap of the steps that happen in a lawsuit and when a creditor goes against the client. So it's really, I've had several clients tell me, I never understood that, and it's just so easy to understand now the way you've written it and everything. So that's very important. So I think that's a really good part of the book. Chapter 7, again, the limitations. I go into what's really exempt under bankruptcy and some of the exemptions like the homestead exemption. And we talk about marital planning. In California, we can do a little bit more than some other states because we have community property. And then I talk about the myth of joint ownership of property. Now, tenancy by the entirety is not a myth. And then the states that have that can be a very effective estate or asset protection planning tool. I don't go into that a lot because, I'm not as familiar with that, but I do point that out, and I assume that any of you in the tenancy by the entirety states that you would amplify on that area when you have your client, and you might even maybe add, if you give the book out, you might want to add a little 4 or 5 explanation about tenancy by the entirety to go with the book, and you could, author it yourself and have that with the book. So it might be a good marketing technique. Chapter 8 talks about liability protected entities, and these are LLCs for the most part. So we go into, and of course the main benefit of the LLC is the charging order. And we talk about, back in jolly old England in the 1800s, there was the charging order concept was developed in common law, and it was really developed to give protection to the non-debtor partner. And so there would be a creditor who got a judgment against the partner and would then try to go against the partnership and get to the assets of the partnership to satisfy the judgment. But the other partner would come in and say, hey, this isn't fair. You're impacting on my rights, and because I have an interest in these assets too, and so you shouldn't be able to seize the assets. That's unfair to me. And over a period of time in the 1800s, and the charging order was developed, the charging order was really just a garnishment on distributions made from the entity. And so normally there would be distributions made from the LLC or the limited partnership going out to the members or the partners. But with the charging order, the debtor partner's distributions are instead garnished and going to the creditor. But then we explain to the client about the exclusivity of the charging order, and making the point that if you draft the LLC operating agreement correctly, you can put the discretion in the manager of the LLC whether to make distributions. And so if there are no distributions, that kind of takes the teeth out of the remedy of the creditor, because they're sitting around with this charging order, but there's no distributions to be made. What that ends up doing really is giving the debtor client a lot of leverage in working out a settlement with the creditor. They can, in California, the charging order is not the exclusive remedy, as it is not in most states. And they can foreclose on the charging order. They can become a permanent economic assignee. And in California and other states, they can even, make the charging order so broad that it turns out to be just a liquidation of assets order. So a forced dissolution. So one of the disadvantages, though, to the creditor of trying to foreclose is that they may have tax liability for the phantom income of the LLC. Somebody has to pay the taxes, and if they become a permanent assignee, economic rights holder, then they're going to be charged. The manager is within its rights to issue a K-1 to that creditor, even though they don't get any of the money, even though the distributions are withheld. As a result of all this, we forum shop. And forum shop means that we go to different states in order to set up an LLC if we're concerned about outside liability and claims against the person themselves. So there are several jurisdictions that are more favorable than others. Delaware, New Jersey, Oklahoma, Arizona have all got exclusive. There's other states now too. Texas, I know, and Florida even now, and as a result of the Olmstead case, the legislation was passed making it an exclusive jurisdiction. But we like to use Nevada and Wyoming. There's a history there of court cases that have backed up the LLC law and the charging order, and both Nevada and Wyoming are the only states that have the single member provision for the charging order. The charging order in other states may say it applies to all LLCs, but the fact of the matter is that because of the Albright case, and the logic behind it, it's a 2003, I believe, Colorado bankruptcy case. the logic behind it is compelling. And that logic is that the charging order was really brought about as a means of protecting the other non-debtor members or partners. So if there are no other members or partners, if it's a single member LLC, then what's the purpose behind the charging order? And in the Albright case, they denied the bankrupt's petition to limit the trustee to a charging order, and they let them go after, step into the shoes of the bankrupts and get to the assets of the single member LLC. But we like Nevada and Wyoming. One problem with Nevada is that it now they charge a $200 annual business license fee. So Wyoming is a little less expensive. The benefit of Nevada is that you can set it up in one day on the internet. Wyoming, you can't do that, but Wyoming's easy to deal with, and it does have a lot of benefits. The problem with Wyoming, the only disadvantage with Wyoming is that it does not have an expedited service. You can't form it in 1 day or 2 days. You don't get any guarantee, although it's usually very quickly done. Nevada does, but it's more expensive, at least by $200, but that's enough to irritate some people. I'll come back to Nevada and Wyoming in a minute. Nevada and Delaware have a series LLC, and what a series LLC is, on the diagram it shows you that it's like having sub LLCs within a master LLC, and the law provides that each series or subdivision is separate and distinct for liability purposes than from the other series. So you could have one LLC, a series LLC, and you could put 3 different properties in the LLC, each one in a different series, and they would stand alone as against the other properties on a tax of liability. The problem is that in states other than Delaware and Nevada, where they don't have series LLCs, and there are other states that have series LLCs, but Nevada and Delaware are the only ones where you'd consider using if you're not in Nevada or not in Delaware, if you're in a non-series state. But you still don't really know how the court is going to interpret that, whether they're going to give credence to the liability protection of each different series. So we're reluctant to use them here in California, even though the State Franchise Tax Board has determined that they will be treated, each series will be treated separately for purposes of the $800 fee that there has. Of course, the state has a strong interest in that, but by a ruling in that way, they've also more or less taken any impetus out of using the series LLC in California, because it's not going to cost you any less than it would. It's going to cost you very little less than it would if you were create just a separate LLC for each property. I don't go into the series LLC in detail in the book. I just point about it because people do hear about it. And I do talk a little bit about the single member LLCs. I've already gone into the Albright case. And the logic of the Albright case is compelling. And I think that in any state other than Nevada or Wyoming, that a court is going to hold that a single member LLC is not going to be limited to a charging order. That doesn't mean that the single member LLC isn't still good against inside debts. So if you have somebody who's only worried about, they own a rental property and they're only worried about protecting their assets from attack by a creditor of the rental property, you're still fine with a single member LLC. But if you're worried about personal liability, then the single member LLC doesn't work. So Wyoming and Nevada, except in Wyoming and Nevada, and even if you have a Wyoming and Nevada LLC, single member LLC in another state, I don't think the other state is going to follow the Nevada-Wyoming law with respect to the exclusivity of the charging order. The Florida statute expressly states that the charging order is the exclusive remedy for an LLC, a multi-member LLC, but it says not for a single-member LLC. So it's more or less adopting the Albright case by law. But as I point out, single-member LLCs still provide inside protection and are still very viable and useful business entities, especially to hold real estate or to provide personal services. In Chapter 9, I go one step further. I use the Domestic Asset Protection Trust, and as all of you know, recently several states have adopted favorable trust legislation that protects self-settled trusts from creditors, and 13 and now 14 states, I think, have adopted such legislation. The Domestic Asset Protection Trust, if properly set up, will be a significant barrier to creditors. It's not foolproof. For example, if you have a California resident who sets up a Nevada Asset Protection Trust, California may not honor the Nevada law with respect to the self-settled trust legislation. However, there are no reported cases that say that they will not honor it. And the reason for that is that every case settles. And so cases only settle when both sides have something to give into and to lose. And so my experience is that they do give protection. They do give a substantial amount of leverage to the creditor, or I mean to the client debtor in dealing with the creditor. And so even if we don't know exactly how the courts are going to, in a non-asset protection trust legislation state, are going to hold, it still does provide a significant firewall and barrier and give the client more leverage. So there's no question that there is a degree of protection afforded by a domestic asset protection trust. I just know that. My clients are litigators. I've seen it time and time again where they've represented creditors who have gone after, and I know what they look at and how they deal with things. And you would get a much better settlement if you had an asset protection trust than if you didn't. Okay, now I'm not like Al Gore. I didn't invent the internet, nor did I invent the modular structure, but I think I've really embellished it a lot, and I have certainly, I think, enhanced it. So the modular structure is where you have the domestic asset protection trust owning the member interest in the LLC. And this is where you can, as attorneys, where you can really benefit your client. You can place the real property or liquid investments of the client in an LLC, but instead of the client owning the LLC member interest, the domestic asset protection trust or the offshore foreign asset protection trust owns the member interest. Now you'll notice that I have a 5% member in the diagram. That could be a dynasty trust for the benefit of the children. It could be, an irrevocable trust of some sort. It can be maybe a sibling. It can be a parent. It can be a close associate, and they can sign promissory notes to get for their member interest consideration. But because of the Albright case and the single member logic behind that case, we always like to try to use another member. Now, some of our clients won't do that, so we go with 100% owned by the trust, but we say that that this 5% member interest gives them it makes it a little better, more protected. Step 6 on the ladder is the offshore asset protection trust, and we tell people normally there are only 3 reasons to go offshore. One is if you've got a lot of money, liquid funds that you want to put over there. 2 is if you have international connections, like relatives are doing an offshore business or owning property offshore. And then 3 is if you really want maximum protection, and then going offshore is the best thing. There's a lot of advantages, and I don't go into this a lot of detail in the book because I want to make it simple again for the client. But the biggest advantage is that the offshore structure takes the structure out of the jurisdiction of the U.S. court system. So that's very important. And it takes the teeth out of a fraudulent conveyance law because of the difficulty of trying to proceed against the transferee. And there's a different standard of proof. It's a criminal standard of proof in civil cases in some offshore jurisdictions instead of the reasonable beyond it'd be the preponderance of evidence test. So it places assets out of the reach of the U.S. courts. It can also be good to people to avoid forced airships in countries, like, for example, Middle Eastern countries. And the creditors are required to try their case de novo in the offshore jurisdiction. We use the Cook Islands, and I explain why the Cook Islands are about 4 hours south of Hawaii by plane and 4 hours west of New Zealand by plane. They used to be part of New Zealand. Now they're independent, and this is one of their government buildings there. And then Chapter 11 goes into the IDIT, Family Limited Partnerships and LLCs, Charitable Remainder Trust, Grantor Renamed Annuity Trust, and qualify the QPERTs. And it does go into a lot of detail, but it just kind of whets the appetite so that as an attorney, if your client reads the book, they may want to find out more about these and come to you. Chapter 12 is a special chapter that I've written for doctors and physicians. Again, it's not a long chapter. It's easy to read, but it does have appeal for physicians. We represent several doctors. I'm representing a doctor right now who's buying into a practice, and it's a complicated situation, and so he's come to me because he knows that I deal with other doctors, and so it's a good source of business. And I think that having the chapter in the book, it's put on the cover of the book, it's a good way to attract physicians and dentists to your office by them having that special chapter just for them. The whole book really applies to them, but having a special chapter just makes it that much more engaging for them to read. Finally, what we do, we climb the ladder and we put it all together, and we tell the client what they need to do. Action number one is to find the right attorney. And so this is where I think you'll appreciate the book because it makes it clear that what they need to do is to find the right attorney to do their business, and then to establish the plan. And of course, you have to work through the attorney to do that, and the advisor is always included. And then to implement the plan, again, working through the advisor and the attorney. And then I give some hypothetical case studies at the book with some diagrams too. And I think that the clients, people who have read the book, really appreciate those hypothetical case studies. There is an appendix listed to the book, and some of you may get a lot of benefit out of some of these documents. A business entity checklist, an LLC explanation that we give to clients, a post-incorporation memorandum that we give to our corporate clients, a post-organization memorandum for our LLC clients, and then an article on why to use family limited liability company, asset protection and marital planning, bulletproofing your corporation. It talks about maintenance and making sure that your attorney does your minutes and resolutions. For whom the bell tolls. For whom the bells toll is an article of why everybody really needs asset protection, how to avoid veil piercing, the Nevada Asset Protection Trust, and putting personal residences into an LLC, a family limited partnership or LLC, why you can't do it, and what to do otherwise. So I think the table of content, the appendix is all very relevant and interesting. And now I want to just spend a few minutes on how I think you can use the book. And by the way, I mean, I'm not saying that this book is the greatest book of all time, or I just think it's a good book for simple understanding of the facts of asset protection and how to use the different methodologies. And I think it can be sort of an adjunct to your practice, both from a marketing standpoint and from a standpoint of really serving your clients. And I think that some of you who don't do a lot of asset protection planning can really learn a lot about it by reading the book. But so you can read it yourself, for your use, whether as an attorney, advisor, or business person. Attorneys and advisors can give the book to potential clients, and I think that by reading the book, it will drum up business. The book doesn't contain any self forms or strategies that can be implemented by one just acting on their own. It's designed to sort of motivate the reader of the book to seek professional advice. You can give a seminar on asset protection and give a copy of the book to the attendees. You can use the book as a means of, as a draw to get people to a seminar. You can give a seminar to physicians and dentists and give the book to the attendees. And they're going to love the fact that there's a special chapter in it for them, and that's going to be very enticing for them because of that. You can write a review and publish it in the local paper or association magazine or journal, or put it on your own website, and that will drum up business for you in that way, because the people will read the book and they'll want to go to a lawyer that can help them set up the program and the strategies that are discussed in the book. A couple of words of caution. Number one, trying an offshore structure, if you've never tried to put one together before, I don't recommend that you do it. I recommend that you co-counsel with somebody who's done it before, because going offshore is a completely different animal and experience. And I would recommend that you co-counsel always on that time, on that kind of a situation, because you have to have the contacts and the networking, an established networking system in place if you're going to try to represent somebody that's going offshore. And it's very, and it's like a foreign animal to most lawyers. I've just was Joe Strazzeri and Steve Mancini, who have a tremendous practice in San Diego, and have created the Laureate program there, and they're really great guys and have a very high net worth oriented practice. They refer their offshore stuff to me because that's one thing that they don't do. They do almost everything else, and they do it well, but that's one thing that they don't do. And so I work together jointly with them on that. But it's the other strategies, I think most of them you're capable of implementing. Some of you haven't done a lot of domestic asset protection trust. We'd be glad to help you on that. Or you might want to, look for some help on that originally, and then you could maybe start doing them yourself after you've had some help with them. Setting up LLCs, and we probably set up between 300 and 500 LLCs a year all over the world. We have favorite jurisdictions in the U.S. It's Nevada and Wyoming. Offshore, we do a lot of Cook Islands because we have the relationships there. We use Nevis. It's an island in the Caribbean, actually the home of Alexander Hamilton. That's on the $10 bill. His picture, and one of the great founding fathers, underappreciated, by the way. But anyway, there are various offshore jurisdictions, and right now I'm in the process of writing an extensive article on LLCs around the world, and I hope to have that published, and that'll be coming out in June. And it talks about every different jurisdiction that has LLC legislation and what some of the rules are and some of the benefits. I think that the book can be a great marketing device for you. At least the cover is well done. And so I think it looks good. It's easy to read. It's not rocket science or anything, but it is presented in an easy way to read for clients, and I've gotten some pretty good comments on it. I'm grateful for that. I'm going to open this up for now for questions, if any of you have any questions.
So if any of you have questions, go ahead and type it into the question bar on the side. I know that somebody had asked if there was going to be a question and answer. One of the questions that was posed earlier was, will will this PowerPoint be available to download? And yes, it will. We'll send you